This is Professor Porter. This course is called Trial Techniques, and it's organized into the following categories. I'm trying to answer some popular questions or common questions that I get in the introductory section. This one's a very popular one. What's wrong with TV and movies portrayal? I love legal movies and TV shows. I got no problem with them generally. I just don't think they're an effective training tool for people that are new to trial skills, people that are in law school that are serious about acquiring trial skills to make themselves a better attorney or perhaps pursue a profession on their feet in the courtroom. A couple different things. TV and the movies definitely emphasizes drama, theatrics, excitement over what it actually takes to succeed and present effectively at trial. So, it's going to focus on that big moment in cross-examination where the witness folds and says, "You got me," and thank you for those great questions. You did it, and I give up and I confess. It doesn't happen in real life. That almost never happens in real life, where you have that type of aha moment where someone's actually, sort of folding on the stand. So instead, what you need to do is effectively prepare ahead of time, understand the formulation and the type of questions you can ask, how to box people in, how to create blocks out of cross-examination, how to string those blocks together to then seamlessly transition into a closing where you're reminding the jurors of all that happened and the points you scored during cross-examination. What happens in the movies and what they depict almost has nothing to do with real life, especially as a discrete skill of cross-examination questions. Similarly, trial attorneys, like all other attorneys in our regulated profession, are bound by all kinds of rules. We have procedural rules, we have evidentiary rules, we have the local rules and of the court, we have local practice, we have, if you're trying a case before an individual judge, that judge is going to have their own rules about their courtroom and what can and can't happen. And what we see on TV and the movies is essentially a lawless society. There's no rules. There's attorneys doing things that are surprising people. There are attorneys that are doing things to pull a fast one on opposing counsel. They're doing things to flout rules. They're doing things to get their backup against judges and call out judges. Well, again, those things are not happening in real life on the regular. Instead, what you see is we have to figure out how to present our case effectively. We have to argue persuasively within the context and confines of all those rules. So it doesn't matter that I've done the hard work of an investigation to know that there's a mode of impeachment that I can use on cross-examination, or there's an exhibit that I can put in through one of my witnesses on direct to help better explain the case and make it more accessible to the jury. If I don't do those things within the context of the rules, both evidentiary rules and procedural rules, I would have had to turn over certain documents in discovery. That's a procedural rule that has to happen before trial, or else it ain't showing up during trial. There's evidentiary constraints of questions that I must ask to lay the foundation for being able to do something at trial. And if I don't do it properly, I'm not entitled to introduce it at trial. That's just the way that works. And then it gets more particularized with the court, with its local rules, local practice, the judge's own rules about how they do, where you can stand, when you have to use a microphone, when you use the podium, how you're going to handle exhibits, how you're going to mark exhibits, how you're going to meet and confer with the other side so it works. All those rules, not even to mention the ethical rules that we're bound by all the time, are sort of cast to the side in most TV and movies, whereas the rules govern everything we do, and you have to learn how to effectively present your case within those rules. And it's the same reason elsewhere in the book and elsewhere in my teachings I talk about, I don't send people down to court to observe court during the semester or during their introductory trial skills, if it's one of their first times training trial skills, mainly because they don't know what to look for yet. This is a profession where you can sort of observe others and you can emulate styles and you can pick up things from other people and make them part of your game, as long as you understand what's effective, what's a good habit to pick up. Instead, I don't want someone going down to court, seeing something that's done incorrectly and then emulating that in class or making that part of their trial skills going forward. That makes them a worse attorney, not a better attorney in the long run. Same thing with TV and the movies. Until you know what you're looking for, until you know what's effective and helpful, there are shows that depict good things that go on in trial. So until you know the difference, I don't want you using it as part of your game. Use it for entertainment only.